I got started to think about this project when I heard the story of a couple of mountaineers who died in an avalanche in the Himalaya a couple of years ago. They attempted to do something pretty crazy, climbing two 8,000 meter high peaks within a week, and using just transport by bike to cover the distance in between. So they set to do a record climb, as they called it, and the whole thing was covered by a German media outlet live, and people were watching. And they aborted the first summit attempt because the avalanche risk was too high. But then, despite the conditions that hadn't changed, they tried it for a second time, and disaster hit, and two mountaineers were killed. So I started thinking about the interaction of athletes, sponsors, because they were all sponsored, athletes, and the media, and whether that facilitated inappropriate or inefficient risk-taking. Well, there are a couple of objectives. First of all, I would like to understand better the mechanisms that cause a certain amount of risk-taking in these circumstances when extreme sports athletes engage in their sport. So this is a social scientific objective. Then, being a lawyer, of course, I think about these contracts and whether there's anything in these contracts that is inappropriate, and whether there might be ways to change the contracting practices between sponsors and athletes to enhance the corporate surplus. And then finally, I'm also looking into the question whether the law should intervene under certain circumstances and override what the parties write into their contracts with mandatory provisions. Well, as far as the current contracting practice is concerned, the challenge was to try to understand how that practice looks like. These contracts are not public, they are private, and so the idea was to, by conducting a series of interviews with market participants, especially athletes, to try and better understand what the current contracting practice looks like. So this is an empirical approach. With respect to the normative approach, i.e. Challenges to the contracting practice and how that could be improved, and whether the law should override the practice under certain circumstances, I was using economic and legal reasoning as legal scholars and economists would do when they evaluate certain practices and consider improvements. It turned out that basically the contracting practice right now in the extreme sports industry, the sponsoring practice, is pretty much unbalanced. So the athletes more or less bear all of the risk while the sponsors reap most of the rewards, basically. So that's one finding. More specifically, I think the empirical analysis has uncovered that the existing contractual arrangements facilitate what I call inefficient risk-taking. That is to say, athletes engage in extreme sports practices or activities despite the fact that had they had the full information, had they not been subject to these contractual constraints, they wouldn't have done it. I think it is important to all those who in some senses participate in these extreme sports as either athletes or sponsors or the courts when they are confronted with cases, or the media or the general public. The whole industry right now, the sponsoring industry with respect to extreme sports, is secretive, and so one of the main objectives of this project was and is to shed some light on what is going on and to start a discussion, a public discussion between the stakeholders in the industry about the current practices and what can be improved.